All right, Mr. Lewis, my understanding you announced is there's not going to be any evidence on behalf of your client. Is that correct?
That's correct.
Okay. All right. Miss Davis, are you want to waive opening and Mr. Creel go, or are you going to open?
No, Your Honor, I'll wait. I'll reserve.
Okay. All right.
Thank you, Judge. My closing announcement is simply this, Judge. One of the requirements of the statute that we have before us is that he either provides contraband to someone, cures contraband for someone, or is in possession of contraband for someone. What we have learned from this officer is that he was not in possession of contraband, actual possession at all. So the only thing that's left is whether he is in constructive possession. Judge, according to the officer, the locker was open. According to the officer, other persons were living in the area. There's attempted to be some misdirection so that we might conclude that my client was the only one who had access to the area. But thanks to the court's repeating of my question, we got the answer, and that is that other persons were in the area. So I would submit to you, Judge, that this officer did not find contraband the week and a half earlier when he checked my client's locker. And on this particular day, 1.5 weeks later, he checked the locker and he found contraband. And just as easily as he opened the locker, everyone else can as well. He said that there was a lock there, but it wasn't locked. I didn't ask him questions of whether the lock worked or not because I didn't want to belabor this point. But I would submit to you that my client is not in possession, whether it's contraband or not. He is not in possession of anything. And if he is in possession, then everyone else that had access to this locker that was not locked was also in possession, and my client is not charged as a co-defendant. So I would ask the court at this point in time to find no cause to bind this matter over. Thank you.
All right, Ms. Pitts.
Your Honor, counsel is making an argument of equal access, which is a defense. It does not go to probable cause. He's entitled to make that argument at the point in time where we're talking about defenses. It is this defendant's locker, and I think the presumption is that he is in constructive possession, that other people additionally had possession, again, is an equal access argument. So therefore, Your Honor, for the purposes of probable cause as to whether or not this defendant possessed illegal narcotics while an inmate, I believe that probable cause has been made out, that a crime probably committed, and that this defendant, based on the fact that it was his locker, was in possession, has been satisfied. For that reason, Your Honor, the state would ask that this case be bound over.
Okay, based on Officer JK's testimony, the court does not find sufficient probable cause. This case is dismissed.
Thank you, Your Honor.
All right, you're welcome. This matter is adjourned. Were you able to determine if Officer Anderson is available?